So on behalf of the Runnymede Society University of Alberta chapter, it's our pleasure to welcome you to this debate. My name is Taylor Thiessen, and this is my co-president, Moira Lavoie. The Runnymede Society is a national organization dedicated to fostering informed, respectful, and thought-provoking discussion and debate on constitutional and legal issues. If you'd like to connect with us or keep track of our events, feel free to send us an email or check out our Facebook page. The addresses for those are listed on the whiteboard there and on our banner. So first I'd like to introduce our panelists. Professor Eric Adams is an associate professor of constitutional law, or an associate professor of law here at the U of A, and teaches courses in constitutional and employment law. Prior to teaching, he practiced civil litigation at a downtown Toronto law firm. Professor Adams has received multiple awards for excellence in teaching and scholarship, and has published widely in the fields of constitutional law, legal history, labor and employment law, and legal education. Mr. Ranjan Agarwal is a partner at Bennett Jones in Toronto and is currently serving as legal counsel at Trinity Western University. Mr. Agarwal maintains a complex litigation practice with a specific focus on class action, commercial, constitutional, and employment disputes. The upcoming Trinity Western appeal will be his third appearance this year at the Supreme Court of Canada. Mr. Agarwal also serves as an adjunct professor at the University of Toronto and has published on a wide variety of litigation issues. So please join us in giving Professor Adams and Mr. Agarwal a warm welcome. So to give a very brief background on the topic of our debate, Trinity Western is an evangelical Christian university seeking to open a law school. Given that it's a private institution, Trinity Western itself is not subject to the charter. All students at the university have to sign a community covenant reflecting Trinity Western's evangelical Christian beliefs and commit to live by it during their time there. Among other things, the covenant prohibits, quote, sexual intimacy that violates the sacredness of marriage between a man and a woman. Some say the covenant is a lawful expression of constitutionally protected religious freedom. Others say it's an unacceptable form of discrimination against LGBTQ individuals. And for this reason, 3 provincial law societies, including the Law Society of Upper Canada, chose to deny accreditation to prospective graduates of the law school. In a little over a month, that decision will be examined in the Supreme Court of Canada. Now, without further ado, I'll turn it over to Moira.
Okay, so I'll just introduce the format of the debate. So each speaker is going to have 10 minutes to provide their opening remarks, beginning with Mr. Agarwal. The speakers will then have 7 minutes each to respond to one another's opening remarks, and then we'll proceed with 10 minutes of directed questions from me to the speakers, followed by 10 minutes for questions from our audience. So I'll now invite Mr. Agarwal to provide his opening remarks.
Good afternoon. I want to begin by thanking the Runnymede Society of the University of Alberta for welcoming me here today. It's always a privilege to come home to Edmonton, where I spent the first formative years of my life. I also want to acknowledge how privileged I am to be speaking today on Treaty 6 lands, the homes of the Métis and our First Nations people. I have 3 points. First, this is probably the biggest charter case of the 2017 term at the Supreme Court of Canada. But I believe this case will probably be the most important administrative law case of our generation. And in many ways, what the Supreme Court will say in this case, and what I believe it ought to say about the overreach of the Law Society of Upper Canada, will be fundamentally important to how we regulate ourselves as Canadians and how we interact with the state going forward. Second, I believe that the Law Society's position here radically alters the role of legal regulators and their relationship to legal educators, including those like the University of Alberta Law School. I also believe it proposes to radically alter how we operate as a confederation. Finally, I believe that this case is the apex of a series of cases on conflicts of rights, and I believe that the Supreme Court of Canada's decision here will be fundamentally important to understanding how we as Canadians are going to live together, work together, and be neighbors in the coming decades, given the multi-ethnicity and the multi-religious heritage of our country. So first, if this decision is upheld, I believe that there is no such thing as an unreasonable administrative law decision. You would have studied, presumably in class, the 2008 decision of the Supreme Court of Canada in Dunsmuir, which in effect says that most decisions of administrative tribunals have to be deferred to. And I pause here to note, when we talk about modern Canadian society, we must recognize that most justice happens at the administrative tribunal level. We may each have our day in court, but it's more likely that we will find ourselves before a landlord and tenant board, in front of a municipal officer, making our case to the regulator or profession, rather than actually standing up and pleading our case before a judge. But what Dunsmuir teaches us is that if a decision falls within a range of reasonable administrative choices, our courts should not interfere. They are barred from interfering. So take that 2008 decision and marry it with the 2011 decision in Newfoundland Nurses, where the court in effect says that the tribunal can render inadequate reasons. The reasons need not be adequate. The court's job is to read whatever reasons exist with the outcome and determine whether the result falls within the range of reasonable outcomes. So where does that leave us in this case? It seems to me that unless an administrative decision maker falls asleep in the middle of the case, or has an undisclosed conflict, or harasses a witness through the proceeding, it will be hard to find a case where the decision is unreasonable. That decision maker can write almost no reasons, and the Supreme Court tells us that a court cannot review the decision. How does that affect the Trinity Western case? Speaking for Ontario, the Law Society's benchers are elected representatives. They do not necessarily have any skill or experience in human rights or constitutional law. The debate in the Trinity Western case proceeded over 2 days with a voice vote at the end. There were no reasons. We as counsel have been forced to rely upon the transcript of the debates, of the speeches that the benchers made. Some of those benchers said nothing, yet voted one way or the other. Some benchers voted and then left, presumably to start into the Law Society's extensive collection of wine, before even the vote was held. So we have really no sense of how the benchers ultimately decided that they were going to render their vote. All we have is the voice vote and the speeches, which, like all good political speeches, were intended to persuade others to their viewpoint. The reasons, that is the transcript, don't proceed in a linear fashion. Many of the benchers don't even speak to the governing legal tests that now form the briefs before the Supreme Court of Canada. No one discusses whether Trinity Western's community covenant is a protected religious obligation under the Amstelm test. People just assume it is or it isn't. Only one bencher turns her mind to the Doré analysis and asks whether this proposed infringement is a reasonable balance with the statutory purposes, without ever citing the case law from the Supreme Court of Canada. And yet, because of Newfoundland Nurses and Dunsmuir, 2 appellate courts in Ontario have ruled, in effect, that the speeches were, for all intents and purposes, unnecessary. All you need to do to decide whether the decision was reasonable and therefore unreviewable is give deference to the Law Society of Upper Canada. If you start from that premise, that these are benchers elected by the profession and they're smart people, and they're entitled to deference even though there's no privative clause, even though they were elected, not appointed as the way most tribunals are, in the fact that they didn't have a hearing but rather a debate, well then of course the decision is going to be reasonable. I mean, there's no reasons to challenge that. I disagree with that. I say that no deference should be paid to the Law Society of Upper Canada. It is not an expert tribunal. Many of its members do not practice human rights or constitutional law. It is a political body, a debating club, if you will. And as a result, in the absence of reasons, and I should say, other municipal bodies, other legislative bodies, like our municipal city councils, our House of Commons, render reasons after a complex debate. The Law Society made a choice not to do so here. And as a result, I submit that they should get no deference. And their decision should be overturned simply on the fact that it is incorrect in law. So that takes me to my second submission. Why is it incorrect in law? I believe that the Law Society of Upper Canada has significantly overstepped its regulatory boundaries. And I'm sensitive to the fact that I'm speaking to a group of students at the University of Alberta in Edmonton, thousands of miles away from Toronto. You may ask yourself, well, why does that matter to us? If I'm going to practice in Alberta or BC or Saskatchewan, what does it matter whether the Law Society of Upper Canada oversteps its regulatory bounds? My argument to you is that if you follow the Law Society's thesis, they say they have the right to govern the admission standards to law schools not only in Ontario, but across Canada. So when the University of Alberta makes a decision about the kind of student it wants to admit, a policy decision, the Law Society has said in its factum, it has the right to interfere with that decision. I say that is a challenge to the very way in which our federation works. Now, what is the Law Society's statutory objective? Section 4.1 of the Act states, it is a function of the Society to ensure that all persons who practice law in Ontario or provide legal services in Ontario meet standards of learning, professional competence, and professional conduct. Dore, which is the leading case on administrative review in the charter context, teaches us that judicial review of an administrative tribunal's charter decision requires the decision maker, the Law Society in this case, to ask how the charter value at issue will best be protected in view of the statutory objective. So it's a lens through which you look at the charter value. Now, going back to section 4.1, standards of learning, professional competence, and professional conduct. I say that the Law Society really has 3 jobs. Its job is to ensure that lawyers are educated, ethical, and competent. When it comes to accrediting a law school, it doesn't need to worry about ethics and competence. That's a measure to be applied to lawyers in practice. All it has to do is ensure that the proposed new law school is going to turn out graduates who are educated. Interestingly, the Law Society of Upper Canada, along with every law society across Canada, delegated that responsibility to the Federation of Law Societies. So, if you want to set up a new law school, you have to send your curriculum to the Federation of Law Societies, and they decide whether your students are going to be educated. And in this case, they did decide that Trinity Western's curriculum met the national requirement of education. So, how is it that the Law Society is allowed to still refuse accreditation? They say they have a reserve power to protect the public interest. And they believe that that reserve power allows them to expand their mandate to, in effect, refuse accreditation to a school they say discriminates against gays and lesbians and on the basis of sexual orientation. What is wrong with that? 3 things. First, TWU is entitled under BC law to discriminate on the basis of sexual orientation. We don't have to like that. We can disagree with that. But the place for that debate is in the BC legislature, not in the debating chamber of the Law Society of Upper Canada. Second, it presumes that the Law Society can determine standards of admission for law schools. And third, it means that the Law Society, a creature of the Ontario government, gets to decide the admission standards for law schools across the Confederation, outside the province of Ontario. To me, that is a massive overreach. Why does all of this upset me? Why does it make me mad as a lawyer in the province of Ontario? Because I believe the benches of the Law Society, with their $1 million wine collection, are fiddling while Rome burns to the ground. The Toronto Star has uncovered dozens of cases of fraud by lawyers that have been not prosecuted by the Law Society because they either don't have the resources or they can't build the case. 40% of all family law litigants cannot afford a lawyer in this country. The Law Society has just concluded a 4-year study that has found that the legal profession in Ontario is rife with discrimination and harassment against visible minorities. And against that backdrop, they spend 2 days debating whether 60 20-year-olds from Langley, BC, who have never been accused of discriminating against anybody, never mind convicted of that offense, should not be allowed to enter the halls of the Law Society of Upper Canada. In my view, and I should just note, Ontario being home to Canada's 20 largest legal employers. The final point in my last minute. This is not a case about a clash of rights. It ought not to be a case about a clash of rights. Let's just follow the decision tree on the outcomes. If the Supreme Court of Canada upholds the Law Society's decision and TWU nonetheless opens a law school, here is what happens. Gay, lesbian, and trans students can go to any law school in Canada. They can be admitted to any law society across Canada. Evangelical Christians, a protected group under our charter and our Human Rights Code, cannot go and be admitted to the Law Society of Upper Canada. They are the group that is affected by this decision. In contrast, if the appeal is allowed, evangelical Christians, like gay, lesbian, and trans students, can go to any law school in Canada, can be admitted to any bar in Canada. The fact is, TWU is not taking away seats from any law school, it's opening up seats. There will be 60 plus more seats at Trinity Western, and that does not affect the number of law students that can attend any other law school in Canada. In my view, the reason why I say this case shouldn't be about a clash of rights is because the only right that's affected are the rights of the evangelical Christian minority that is at the receiving end of the Law Society's decision. Let me just end with this point. I think it has become fashionable in the media to beat up on evangelical Christians. On one hand, we don't like the fact that the government prevented Zanera Ashok from wearing her niqab when taking the citizenship oath. We don't like the fact that Gurbaj Multani can't wear his kirpan when going to public school. We celebrate the fact that Jagmeet Singh wears a turban. We're offended at the fact that Quebec thinks you can't ride a public bus if you're Jagmeet Singh or Zanera Ashok. We seem to be prepared to protect the rights of certain religious minorities. But for some reason, we've conflated evangelical Christians with a majority in this country, when that simply isn't the case. And I would submit to you that if we do not wholeheartedly protect their right to open a law school, their right to protect a faith, no matter how much we may disagree with its tenets, then ultimately we do violence to every religious group in Canada's rights to be free in this country. That is why I think the Law Society has to open its doors, forced or not, to all faiths. Thank you.
Hi, everybody. Is that on? Does that work?
Oh, yeah.
Well, thanks to the organizers for inviting me, and thanks for Ranjan for coming back home and participating. I want to just open by acknowledging that by taking off my glasses, and then I want to acknowledge that this case raises deep and personal issues for many people of identity, of belonging, exclusion, and discrimination. And I say that referring to both groups of individuals who feel most deeply implicated in this case, that is LGBTQ students, prospective students, and also evangelical Christian students and prospective students. These are difficult issues, and resolving them demands that we listen to one another and consider one another's views that we may not necessarily hold and share. And that's a structural feature of the law and legal discourse that I think we need to especially champion and promote in a time when that's not always the case these days. I also want to just lay out a few basic constitutional administrative law principles that I think are important. The Charter of Rights and Freedoms, in my view, guarantees principles of individual and group autonomy, dignity, but also balance and proportionality, respect for difference, and democracy. A constitutional rights instrument, the Charter is, I think, carefully attuned in both its language and its interpretation to the diverse realities of Canada. And the fact that individual rights are not absolute, especially when they interact with other rights and freedoms and state interests in the wider society. Canadian administrative law is similarly guided by principles of rights, balance, respect for diversity, but also democracy. Judicial review, the Supreme Court of Canada has said, and I'm quoting, should be guided by a policy of deference, justified on the basis of legislative intent, respect for the specialized expertise of administrative decision makers, and recognition that courts, and this is sometimes, we don't say this enough in law school, courts do not have a monopoly on adjudication in the administrative state. Applying these broad principles to the TWU case can help us steer through a dispute that appears on first instance to be an intractable battle of rights and absolutes. So these are the premises on which I want to discuss this issue. Some of these are being contested by the parties at the Supreme Court, but I don't have to contest them because I'm not a litigator in the case, and I can just immediately move to reasonable positions. So, I think it's reasonable to agree that Section 2A, freedom of religion, is one of the hallmarks of a free society. As the Charter describes it, it is fundamental. Religious freedoms protect, as the Supreme Court of Canada has said, not only the right to hold beliefs, but the right to manifest those beliefs, not only alone, but in concert with others. Those religious communities have a right, then, to manifest beliefs with which others will profoundly disagree. Indeed, beliefs which may not fully align with other charter rights and values. Section 15 equally is essential to a free and democratic society. Equality rights affirm human worth and dignity by prohibiting discrimination on prohibited grounds. Canadian constitutional law then must accommodate and protect a pluralistic society in which rights to difference are maintained and a right not to be discriminated against is protected. In my view, Trinity Western is exercising its religious rights under Section 2A in creating an educational community dedicated, in its words, to a firm commitment to the person and work of Jesus Christ as described in the Bible. But I also take it as a given that the TWU's community covenant discriminates against the number of groups and individuals by making it impossible for some, not all, but some, to sign the covenant in good faith and to attend Trinity Western. It clearly discriminates on the basis of faith and religion, and it discriminates against LGBTQ persons by defining sexual intimacy as reserved, that's its language of the covenant, reserved for marriage between one man and one woman. TWU, and I think it's important to stress this, is seeking an accreditation from law schools. Some have agreed to accredit TWU. Other law societies, notably Ontario and BC, have not. This is the only question that is before the Supreme Court of Canada. Was it reasonable, giving full deference to the law societies and their expertise in regulating the legal profession, was it reasonable that those law societies have refused to accredit TWU because, in their view, the discriminatory admissions policies did not accord with the statutory mandate to protect the public interest, given the harms to dignity and self-worth that a discriminatory admissions policy maintains? Well, what does the law say? Well, Dore, it was mentioned by my friend, I think is the governing case here. And in that case, a unanimous Supreme Court of Canada tells us how we make these decisions. Number one, the administrative decision maker must consider their statutory objectives. And two, they must then consider and balance the charter rights that are in play in making that decision. The decision that they make need only be reasonable, in that it, quote, falls within a reasonable range of acceptable outcomes, and given deference that courts owe to administrative decision makers given their particular expertise, not the court's expertise, but the administrative decision maker's expertise in how to govern under their statute. Ontario has been exercising that expertise since 1797. Okay. Was the decision of, let me focus on Ontario. Was the decision of Ontario to refuse to accredit TWU Law School reasonable? I think it's pretty hard to argue that it was not, especially since that decision was premised on important and fundamental distinctions between private and public acts of discrimination. Religious freedoms cover a laudably wide ambit of activity. It is not only, as I said, beliefs that are covered, but communal practice of those beliefs. But the wide ambit of those protections, the fact that you're protected not only in what you believe, but the actions you undertake under those beliefs, creates consequences for increased limitations when those beliefs and actions run up with others in the public sphere. In this case, TWU is not seeking a right to exist, not the right to gather together and to hold beliefs, not the right to form a law school without interference. Rather, it is seeking the right that other law schools, other law societies, indeed all law societies, are required to overlook its discriminatory policies and grant it a rare and valuable public benefit, the accreditation of a law school, the gateway to the legal profession. Well, Ontario recognized in its debate at the Law Society that TWU possessed valid religious rights, including the right to exist as an educational community. But what it denied was that it was required to become a party to the discrimination contained in the community covenant in the form of granting its accreditation. Rather, it took the fully reasonable, in my view, that quality of access to all, and that the promotion of an ethic of non-discrimination against the vulnerable minority was a core value that the legal profession was entitled to protect in the public interest. And it did this against the backdrop that it's worth bearing in mind, that the Law Society has had a history of exclusion of vulnerable peoples, women, blacks, sexual minorities, both formally, but for much of the 20th century, informally, were barred from the practice of law. Other societies, other law societies, have come and may continue to come to a different conclusion. I'm going to suggest to you that they're reasonable in making that different calculus on where to equate the balance between religious freedoms and equality rights. But is it unreasonable that Ontario said that their view of their statute was to promote equality of access? I think it's hard to say it's unreasonable. Finally, let me close here. I think there's an irony in the position that TWU is advancing. It emphasizes its rights, but refuses to recognize the existence of any other rights in play. Its vision of the Constitution, far from promoting and protecting diversity, actually demands a one-size-fits-all answer across the country. It opens the door, in my view, to discrimination for other institutions against other valuable persons in the legal practice, and that is something I think it is fully reasonable for a law society to object to be a part of. Thanks very much.
I guess in some respects, we are two trains in the night, because Professor Adams is really talking about what the law is, and I'm trying to persuade you what the law should be. In that I accept, so let me rebut this point in two ways. First, let me deal with why I say the law should ignore Dore, why I think Dore, Dunsmuir, well not Dore specifically, but Dunsmuir and Newfoundland, with the extent to which Dore adopts them, is not good law any longer, nor should it be. And then let me discuss, well, if the Supreme Court disagrees with us on that, why I still think, even with respect to Dore, this was an unreasonable decision. So, again, Dunsmuir effectively says that tribunals should be given deference because they are at, if you will, the street level of our administrative state. And the decision makers that we appoint to those tribunals have an expertise. I get that argument if you are an appointee to the Labor Board or the Human Rights Tribunal or the Employment Standards Branch and you have spent your life working in human resources. I get that if you're an appointment to the Municipal Board and you are a planner by trade. What I don't understand is why we have decided that all administrative tribunals, including a political body like the Law Society of Upper Canada, should get prima facie deference. So again, the Law Society of Upper Canada and the 38 benchers that made this decision are expert in almost nothing. I mean, they are expert in their substantive areas of practice, but they have no expertise in religious freedom. They have no expertise in balancing of rights. They have no expertise in the application of administrative law. There are criminal lawyers and immigration lawyers and general practitioners, and they were elected to that position. There was a popularity contest that determined that they would govern the profession. I take no issue with that process. What I take issue with is the idea that because they are part of the administrative state, under Dunsmuir, they are entirely entitled to deference without even second-guessing the fact that when they sat down to make this decision, they actually didn't know any more or any less than any one of us in this room. The only difference between them and us is that they were elected to that position. The converse is that they might have been able to remedy that problem by writing reasons that were cogent, logical, transparent, thoughtful. If they had charged a committee with drafting majority reasons that reflected why there was a breach of Section 2, why they believed that there was an appropriate balance between that breach and their statutory purpose, then they might be entitled to some deference because we as a community would have something to look at as a justification for their argument. But instead what they do is they actively decide not to do that and force us to rely upon their debates. It's the equivalent of you sitting through a lecture for an hour, hearing what all your classmates said, and at the end of the class, the professor saying, that is the exam. That's not your score, that is the actual exam. There's no need to write anything down. I can just rely upon what everybody said in class, whether those were musings off the top of their head, whether that was rhetorical flourish to persuade your seatmate, or whether that was actually a substantive thought based in law. So, for that reason, I say they are entitled to no deference. I say that the Supreme Court of Canada has to review this decision on a standard of correctness. And when they do so, they will see that the decision is wrong. Why is it wrong? And this gets me to my second point. Whether it's unreasonable or incorrect, it's wrong because the Law Society's objectives in its statute are not to be a defender of human rights across Canada. Their objectives, the powers that have been granted to them by the legislature, are to ensure that you and I are educated, ethical, and competent. Full stop. They have decided amongst themselves that they want to be some sort of quasi-constitutional human rights tribunal that gets to decide and pass judgment on other institutions in Canadian society because they don't agree with the way in which that institution is practicing its faith and its beliefs. Now, I could understand if this was some body that was not subject to the laws of Canada. But the perverse rationale or reasoning is this. Trinity Western is formed by a statute of the BC legislature. It is exempt from the Human Rights Code. It is not bound by the Charter. That is a decision that we as Canadians have made regarding Trinity Western. Contrast that with law schools in Nigeria, Saudi Arabia, and the rest of the Middle East. There is no objection. There is no facility. There is no way of avoiding the fact that law students from those schools in countries that make homosexual conduct illegal and criminal can be and are admitted to the Law Society of Upper Canada. So the confusing fact of the Trinity Western decision is that we are more than happy to accept immigrants from other countries who have studied abroad, who come from law schools that have the same, if not worse, policies in the eyes of the Law Society of Upper Canada as Trinity Western. And yet, we are refusing accreditation to a law school that is a creature of the BC legislature. If you and I, outside of this forum, disagree with the covenant, if we think it is wrong, if we think it is discriminatory and it has no place in society, then the place for that debate is the BC legislature. It is not at the Law Society of Upper Canada. Once the BC legislature and the BC Advanced Ministry of Education decided that Trinity Western can operate, I say that the Law Society has to stick to its knitting. It has to ensure that the students are going to be educated, ethical, and competent, and nothing more. Let me end with this point. The Law Society's factum, and Professor Adams both talked about the Law Society being a party to discrimination. Go back to that thought exercise at the end of my opening submission. If this policy is upheld, the Law Society will be an active party to discrimination against evangelical Christians. Trinity Western will open its law school. One day, a Trinity Western graduate will knock on the door of the Law Society of Upper Canada and ask to be admitted, and they will be refused because they went to an evangelical Christian law school and practiced their faith. The converse is that if this decision is denied or the appeal is allowed, then ultimately evangelical Christians, gays, lesbians, and trans students anywhere in Canada can all equally be admitted to the Law Society. I say that the Law Society is only a party to discrimination if this decision is upheld, and that's what makes it incorrect at law. Thank you.
Thanks. Well, I'll just be brief, and then we'll have some time, I hope, for questions. I just want to respond to a few of the points that have been raised. The first is, I don't think we get very far in conceiving of the administrative state if we ask administrative actors making decisions in that state to perform exactly like courts. And when they perform like courts, then courts will owe them deference, and if they don't perform their activities exactly like courts, we won't. That's a strange vision, I think, of administrative decision-making, and it's a strange vision to me about how something like the Law Society of Upper Canada and other law societies can operate by democratically elected ventures governing in the interests of the public and the profession. So let me tell you a little bit about what did happen at that TWU debate. It wasn't the case that the ventures showed up that day, dipped into the ample wine supply, as has been mentioned, and were discovered to find that they were having Trinity Western's rights on the menu. It wasn't the case that the Law Society of Upper Canada went looking like a busybody with what educational institutions can we interfere with today. Rather, TWU placed the decision of their accreditation on the laps of the Law Society of Upper Canada. They had a decision to make. That decision was, should we accredit or should we not accredit this institution, as is our duty under the statute? They took that obligation seriously. So seriously, in fact, that they dedicated 2 days to discussing the issue, which is a lot longer than they took to decide about disbanding a name that they've had for 270 years. No longer will they be known as the Law Society of Upper Canada. That decision they made quickly. This decision they did not. For over 4.5 hours, speakers discussed the issue. As the Ontario Court of Appeal said, they did so thoughtfully, eloquently, and with passion. They knew they were making an important decision. They had the president of TWU address the benchers of the Law Society of Upper Canada for over an hour. He did so, putting his position to them plainly and clearly. They also commissioned, as lawyers like to do, legal opinions on what the constitutionality and legality of this decision would mean. And after all of that, made their decision. I think it's hard, again, to say that it's simply unreasonable because they didn't do it like a court does it by writing a comprehensive set of reasons. Let me also read you section 4.2 of the Law Society Act governing lawyers in Ontario. Section 4.2 says, in carrying out its functions, duties, and powers under this Act, the Society shall have regard to the following principles. And then at number 3, it says, the Society has a duty to protect the public interest. Supreme Court of Canada, in a case earlier this year, I believe, said that that definition of the public interest is best left to the law societies themselves and their expertise to define, and to define the ambit of. Finally, on the question of who is being discriminated against if this decision not to allow the accreditation of Trinity Western graduates carries forward. Again, it's hard for me to conceive that evangelical Christians are being discriminated against, since the Law Society of Upper Canada never asks individuals whether they're evangelical Christians, certainly has never denied entrance on the basis of being an evangelical Christian, indeed has many practicing lawyers that are evangelical Christians and will continue to do so. What the Law Society says is that in exercising its duties, it cannot accredit a law school, as is, again, within its statutory mandate, accredit a law school, which alone, no other law school in Canada is similar, alone would seek to have as its admissions requirement a discriminatory policy against LGBTQ students and others. That is something that the Law Society properly has within its mandate, and it was reasonable in exercising it as it did. Happy to get your questions. I don't know, maybe Maura, you're next.
Yeah, I'll just direct a couple questions to you guys, and I'll stand over here so I'm not awkwardly standing in front of you. And then we'll open it up to the room. So I'll direct this at Ranjan first, maybe, and then Professor Adams, if you want to respond as well, you're welcome to. So even if the decisions of the law societies of BC BC and Upper Canada and Nova Scotia not to accredit TWU are upheld, the program would still currently be accredited everywhere else in Canada. And this means that while TWU grads could not practice law in BC, Ontario, or Nova Scotia, they could still choose to go to practice law in the majority of Canadian provinces and territories. And is this not analogous to TWU's argument that prospective law students who take issue with its community covenant could simply choose to attend law school somewhere else?
So, let me begin with a couple of premises to that. So first of all, I don't think it's a foregone conclusion that if Ontario and BC do not accredit, that TWU will be allowed to open its doors. I think definitely in the case of BC, the Minister of Advanced Education has made clear that in the absence of local accreditation, they will not allow the law school to open because you need to get approval from the minister. So I do think in some ways the two are baked into each other. I also don't think it's fair to require Trinity Western or allow Trinity Western to open up a law school, but in effect say to its students, sorry, but you're blocked from entering the largest legal market in Canada. I think there's a market economic problem there. So, but leaving that aside to the more theoretical point, I appreciate that there may be the equivalent of saying, look, you can get accredited in Manitoba, sorry, it's not going to happen in Ontario for you. But I don't think that changes the discriminatory effect of it. TWU has a protected right. And again, I'm not suggesting we all have to like it. Like when I say that it's a protected right, I'm not suggesting that I'm going to be the sole defender of it. But TWU has a protected right to discriminate against same-sex couples. That right is protected by the Human Rights Code. It's protected by the fact that TWU isn't governed by the Charter. So it's allowed to do that. We don't have to like it, but it's allowed to do that. In the converse, the Law Society exhibit isn't allowed to say that because you're an evangelical Christian university, you cannot become a lawyer in Ontario. And I think that's where the inequality of arms is.
Okay. So I guess, would you say then that, for instance, the Ontario Court of Appeals decision to uphold the Law Society of Upper Canada's decision has the effect of subjecting a private institution to charter scrutiny? And if so, what are the potential legal implications of this beyond the TWU situation?
So, I think the short answer is yes. And I think the way in which the Court of Appeal ends up there, and I think they're directed to do this by Dory, is because of this amorphous concept of charter values that has creeped into our jurisprudence. So in effect, if you have to balance anything against a charter value, you don't have to apply the same rigorous legal test that we have invoked under Section 2 and then Section 1 to determine whether there's been a breach and if it's been saved. And so the result of that is that they're entitled to say, look, these values, they just aren't what we want for our law school here in Ontario, for our law society here in Ontario. And as a result, we're not going to accredit this law school. And I would agree that what that does is it converts the ambit of the charter to governing only state institutions, including the Law Society of Upper Canada, to one that governs non-state institutions. And I don't think it's unreasonable to say it's a short hop, skip, and jump away to say, look, we can start applying charter values against the individual actions of people in society if we can apply them against actors who aren't subject to the charter.
I guess I'd just add that for me, the important distinction here remains, and these lines can be fuzzy, but the line between private and public. So the reason I'm not overly concerned by a law society that's taking charter values into consideration is because the Trinity Western Law School, in this case, or prospective law school, is seeking a particular public benefit. It's not asking whether or not it has a right to exist or educate. What it's asking for is the right to allow its lawyers access to the Ontario legal market. And Ontario, it seems to me, is compelled to consider charter values in making that determination. And we make this distinction in other areas of the law and other difficult areas of human rights law as well. So again, as has been pointed out, we don't have to like the views of religious groups, but they have the right to have them. And I don't think we want to live in a society in which those rights weren't allowed to be different from mainstream views. That seems to me to be part and parcel of living in a free society. But when an individual says, now I open up a bake shop and serve the public, we don't say that it's acceptable to turn away gays that are seeking a wedding cake. We say that now, although we respect your right to hold those views, it's important that in order to function in a pluralistic society, if you're in the business of selling cakes, you're going to sell them to people that come through that door. And what we don't want to do is to return to a society in which some people are welcomed in some public establishments and some people aren't. We had that in Canada for a long time. And you know what? The answer to them was the same as the answer that's being given now. So when Fred Christie walks into a bar in 1936 Montreal, and they say, we don't serve blacks here, when he argues that case at the Supreme Court of Canada, the lawyer for the bar says, there were lots of other bars you could have gone to. Why do you need to come to this bar, where the rights of the proprietor are being infringed by forcing him to serve you? It was the rights of the proprietor that were in play. It was the argument that, hey, if people are drinking at this bar, that just opens up other bar stools elsewhere in the city. Go where you are welcome. And that argument, which succeeded in 1939, I don't think should succeed today, because we have a different appreciation of what it means to live in a society in which doors are open to all, in which access to public benefits exist for all.
So, you are surely smarter than me, but both of those arguments fall down this way. First of all, with respect to the baker example, replace the baker with the regulator and replace the gay couple with an evangelical Christian. It is no different. The Law Society is barring entry to evangelical Christians simply because they went to Trinity Western. And the reason why they chose to go to Trinity Western is that they want to practice their faith and they want to learn their law in a shared community. So I appreciate this is a challenge. There are rights in conflict and need to be balanced. But the question, I think, has to be not about the effect on gay, lesbian, and trans students, but rather the effect on evangelical Christians, because those are the ones that are being refused entry. On the flip side, I agree. Bars should not be allowed to discriminate against blacks or Jehovah's Witnesses or anybody else protected under the Human Rights Code. The difference, though, between that example and here is that the British Columbia Human Rights Code, through the wisdom of the legislature, has granted a specific exemption to Trinity Western University. It is exempt. It is allowed to discriminate. And so if the legislature has spoken on that point, I say the debate is for the BC legislature, not for the Law Society of Upper Canada.
All right, thank you. I think we have about 10 minutes for questions from the audience, so please raise your hand and I'll... Taylor?
I think just moving to that topic of public benefit, is it fair to characterize admission to the Law Society as a public benefit? Because you need that to be a lawyer at all. It's not, I mean, the gate is otherwise barred to you. So is that a benefit, or is it just a detriment to be refused?
So if I understand the question, so the question is it a public benefit that's being conferred in having an accreditation by a law society? I think it pretty clearly is, in that not all institutions have that accreditation, that only a select number of law schools in Canada are accredited, and then once you are accredited by a law society, in this case Ontario, it gives you access and an entitlement to article in that province. Failure to have that accreditation means that you don't have that access, and that's a valuable resource that institutions might like to have, but that the Ontario Law Society has the ability to confer or not on the basis of its statutory mandate.
Yes, it was Richard.
It was mentioned by your opponent that it seems as though there's a discrimination because the Law Society is allowing people and students from other countries with much more severe discrimination. They are allowing them to come and be admitted to the bar and allow them, but then they disallow students from TWU, does that not seem like they're not necessarily drawing a line of standards, but they're drawing a circle around TWU?
Thanks for the question. Is it helpful if I repeat the question because of the taping, or?
No, it's all right.
No, I think
We're
we're
good?
okay, as long as
Okay.
you guys can hear it, yeah.
So I think I just want to correct the factual record on that point. So the Law Society of Upper Canada does not grant access to individuals from other law schools outside of Canada. What happens is that the Law Society of Upper Canada, if you graduate from a non-accredited Canadian law school, subjects those individuals to the screening of the NCA, who then will evaluate what other and additional courses you need to take, what steps you need to take in order to be allowed admission to the Ontario Bar. So there are a number of additional obstacles and hurdles in the way of anybody seeking admission to the Ontario Bar who is not from an accredited Ontario law school. So in the case of a law program with a discriminatory entrance environment, those individuals, if they're seeking admission to the Ontario Bar, are going to be required to write a number of competency exams before they are admitted to the bar. Now, what Ontario is saying is that, again, that may well be the case with how to handle TWU graduates. That's one option. That they haven't said that one way or the other, but they have, what TWU is asking for is something different, which is automatic entrance to your articling process, just like a graduate from any other law school.
So you're exactly, and I didn't mean to misstate the fact, you're exactly right about the process. I guess my issue is that, first of all, nothing in the NCA evaluative process considers the policies of the student's school or government before they come to Canada. It's entirely based on educational merit and competency. And so the Law Society surely has licensed lawyers practicing in Ontario who are graduates from schools that have more draconian standards than Trinity Western. And they have done nothing to prevent that. They don't have a rule against it. The second thing is that I don't think it's fair to Trinity Western to say to them, listen, you go open up a law school, and we'll see if your graduates can become licensees one day down the road. We don't know what hoops they're going to have to jump through. They may have to do another 2 years of law school like some NCA students. They may not. They may have to write all series of ethics exams. But we're going to wait and see, and we're going to judge that on a student by student by student basis. The whole point of accreditation of Canadian law schools is we accept that in Canada there is a minimum standard of legal education which has been approved by the Federation under the national requirement, and as a result we allow those students in effect to come to the Law Society without worrying about being tested again. And what the proposal in effect of the Law Society, which is implied in their materials, is that even if we don't accredit the law school, no problem, we'll have an NCA type process for Trinity Western students. I say that's just separate but equal in another fashion.
Okay, Justin?
Thank you. Professor Adams, regarding what you said in response to the previous question about how Trinity Western students would not automatically be excluded but face additional hurdles, in what sort of additional hurdles would serve the public interest by correcting or compensating for Trinity Western's discriminatory policy?
That's a great question, and I have no answer. In fact, I don't know what the right way to get out of this problem is. So I don't want to be saying that competency exams is that magic bullet, because I think what the Law Society has said is that they're concerned. Indeed, their statutory mandate compels them to be concerned about a discriminatory institutional policy, not about the competencies of individuals who may or may not graduate from this law school that doesn't yet exist. And so how do you remedy an institutional deficit in terms of a discriminatory policy? It's not really clear to me what the easy answer there is, and none have been proposed because TWU isn't interested in that outcome either, at least at present. They're interested in full accreditation, but no, I think that's if TWU goes on to exist, as I think, again, as I want to stress, it has as a Section 2A right to, and if the BC government continues to think that this is a valuable, that the institution can exist under BC law, then that's going to be an issue that law studies have to face. I don't know if Ranjan has any thoughts on that.
Yeah, I mean, and so I always hate it when speakers get up and do a disclaimer at the beginning, so I didn't do that at the front, but on this question, I'll just say these are my own views, not the views of Trinity Western, so I don't want them showing up in a factum somewhere. But I think, and I think in fact we may have argued a version of this in oral argument in the Court of Appeal. One of the things that we said to the Court of Appeal was that if you read NS, the case about the Muslim woman who wanted to testify in a criminal trial wearing a niqab, the court in that case said it is up to the decision maker to fashion a remedy that reconciles the rights. And so I would have said here that if you apply that to Trinity Western, the Law Society actually had to undergo the exercise of the very question you just asked, which is, all right, there's an infringement of Trinity Western's religious freedom. Trinity Western itself infringes the rights of gays and lesbians under, well, no law, I would say, but in any event, infringes it in a public policy manner. And so how do we reconcile the fact that Trinity Western has a right to be accredited, and yet they have this discriminatory policy? And they might have done that through, and I go back to competency, ethics, and education, they might have done that by saying Trinity Western students have to take an extra class in charter rights, I don't know, or family law. Students are going to have to do CPD requirements when they become young lawyers in that same area. They might have answered it that way. I think part of the reason why it's hard to come up with a solution is that in some ways you rely upon the regulator to do that. They know what are the regulatory tools available to them. But I think another reason, because of time I didn't lay it out for you, but I think another reason why this decision falls down is that the Law Society treated it as an either or, an all or nothing, when in fact what they should have done is try to reconcile the two competing rights like NS teaches us they have to.
Okay, we'll take our last question from Dylan.
I just had a question for Ranjan, just on the standard of review type issue. I think you've made some good points. If the standard of review was correctness, I agree with Professor Adams that on a reasonableness standard, it's difficult to say that the decision was unreasonable. If we look at the deficiency of the reasons, it sounds like you're saying that a deficiency of reasons makes the standard of review correctness. And I don't think that's necessarily the law. So if really the only issue is that they didn't provide sufficient reasons, what sort of remedy is TOU looking for, and to what end if we just send it back for reasons, basically?
Yeah, so good question. So I think my argument is that the lack of reasons means that we don't give them deference. And because we're not giving them deference, because that's how you determine the standard of review, as a result it should be correctness, not reasonableness. And I agree with you. One remedy may be, it would be terrible after all these years if that were the remedy, that the Supreme Court of Canada sends it back to the Law Society of Upper Canada and says to them, re-engage in the debate and justify your reasoning. I will say to you that having read those reasons over and over and over again, and have seen the video and listened to them in preparation for the case at all levels, I do think there is a difference between what we say in an oral debate and what we are prepared to reduce in writing. I mean, you all know this from class. You're prepared to put up trial balloons all the time in class in order to test your learning. You want to persuade your classmates to your view, you want to have a good debate. But when you actually reduce your answer to writing on the exam, you're going to be a lot more cogent, thoughtful, and ultimately, you may decide that your view on the case is different than what the law requires you to do. And I say that if they had turned their mind to the legal question, so remember, Professor Adams here has conceded that there's a breach of Section 2. There are many benchers that refuse that concession. So the question I'd have to ask to begin is, when those benchers sat down to write reasons, are they going to be reasonable? Is it going to be reasonable for them to refuse to concede that there's a Section 2 breach here? And then, if they're forced to turn their mind to Doré the way a judge or an administrative decision maker might be, and they read that passage Doré that says you have to balance the infringement, which in this case is on evangelical Christians. The infringement is not on LGBTQ students. You have to balance that against a statutory purpose, and they go to their statutory purpose. Is it going to be reasonable for them to conclude that the only way to balance that, given what NS says about reconciling rights, is to refuse accreditation? So maybe I'm being optimistic in that reasons I think would have led to a correct decision. Maybe it's a little bit of after the fact thinking.
But I think the lack of reasons is a telltale sign of the problem with the whole process of the decision.
Okay, thanks everyone. Please join me in thanking our speakers.